Am I audible? So, let us start with our lecture on right to freedom of religion. Right to freedom of religion. We have already seen Article 25. Article 25, which talked about the right of a person living in India to have freedom of conscience subject to morality, health and public order. People living in India can profess, propagate and practice their religion. That was all about Article 25, and it also tells about the state interference, how far and how deep state can interfere. Whenever there is a question of public order, health and morality which is being hampered because of the fundamental right of religion, the state needs to enter in. Also in the secular activities which is around a religious organization or denomination, that also will be administered, managed and maintained by the state. Not always the fundamental right to manage and administer has been given to the religious denomination, but state can also interfere in that, all the secular activities, not in the core religious activities. Then comes the third thing about social welfare. Article 25 also talks about social welfare. State can come up and make laws, rules, regulations for the social welfare, and if it is infringing religion in any way, that is allowed. That interference is allowed by the state for the social welfare. Throwing open of Hindu temples of public nature, that is also allowed to eradicate untouchability, because in several Hindu temples untouchables were not allowed. So the state have made the provision, the constitution have made the provision that all such Hindu temples must be thrown open to the public. All of them can enter them and they can profess, propagate and practice their religion. That is the right given to the citizens, right also given to the non-citizens who are living in India. Now in this lecture our focus would be on Article 26, 27 and 28. These three things are also fundamental rights which tells about few other activities. They are more specified and particular. Article 25 is a broad article which talks about the propagation of the religion, profession and practice of the religion, subjected to few exceptions which are given, and the state interference. But Article 26 is more particular and it talks about religious denomination. Then comes Article 27 and then 28. They all talk about different things. This about taxation. Article 27 talks about taxation, that no tax can be levied whose proceeds are going to be used for the promotion and maintenance of any religion. So taxation not allowed for promotion and maintenance of any particular religion in India, means a state cannot levy any taxes on the people. People must not be compelled, but there are few exceptions. We will study that also. Then comes Article 28, which talks about educational institutions. And religious instruction given in the educational institutions, where it is allowed, where it is not allowed, where it can be done through the consent of the person to whom this is given. What about minors? Can you take the consent of minors also, or the consent has to be given by the parents? These are all little things which are covered under Article 28, the educational institutions and the religious instruction given in it. Instruction given it. So, we will go directly to Article 26 about religious denomination. Article 26. All the religious denomination have the right of freedom of religion. Okay. There are 4 conditions which are specified for the religious denomination under Article 26. We will study those. 26A talks about establishment and maintenance. Establishment plus maintenance of religious and charitable institutions. Establishment and maintenance of religious and charitable institutions. फ्रीज है. Okay, so a bit of a technical mistake, but let us continue. So, it is about establishment and maintenance of religious and charitable institutions. This is a very important article as far as the religious denominations go. Then the other thing which comes up is B. The religious denominations. These religious denominations can manage their own affairs. Manage their own affairs. These religious denominations can manage their own affairs. What kind of affairs? These affairs are related to the matters of religion. Matters of religion. Then C, 26 clause number C talks about owing and acquiring the property. They can own and acquire property for religious matters. Okay, and then the last one D comes, where it says that the religious denomination can maintain and administer the property according to law. Now, there are few nuances in all these 4 conditions which are given under Article 26 clause B. Now, let us go one by one deep into it. When you say religious denomination, what do you mean by religious denomination? If we see, we have major religions, Hinduism, Islam, Christianity, but there are few denominations of such religion also. Okay, what do you think about Chishti sect? What do you say about Sufi sect? Okay, what do you say about Jehovah's Witnesses, or for that matter Ramakrishna mission propagated by the great Ramakrishna Paramhans? These are all considered to be religious denomination. So there are few conditions which have been applied by the Supreme Court in its observation about which organization to be considered as a religious denomination, because it has its own perks. Article has been dedicated for religious denominations only. So it is important to specify which organization or which belief system can be considered as a religious organization. It is important to specify the conditions. So Supreme Court has came up with condition, few of them important 3 conditions needs to be applied here, and that is that they need to have some sort of belief system. Some sort of belief system, the tenets of which must be based in religion. If the tenets are not based in religion but into something else and they call it belief, that organization will not be called as religious denomination. All the categories needs to be fulfilled, not only 1 or 2, all the 3 categories which I am going to say here, those categories have been specified by the Supreme Court and needs to be fulfilled in order for an organization to be called as religious denomination. One is they need to have some sort of belief. The belief must be based on in the religion. The belief cannot be of something else. Okay, it has to be religious belief. So one is belief. Second important thing, needs to have an organization. Needs to have some sort of a body, some sort of organization. It cannot just be a belief system where few people here and there believe in it. It needs to form an organization. So it is sort of an organization with individuals who believe into something, and those beliefs are originating from religious beliefs. So third will be naturally individuals. And it needs to have plus a separate name. So these are the 3 important conditions. So anywhere if you find, let's study it with a few examples here. Chishti sect and Sufi. If you look closely, they have a different name, they have a separate name, Chishti and Sufi sect. The belief in Chishti sect and the belief in Sufi sect, which is more liberal form of Islam, they are originating from Islam only. So the religious tenets, the belief system here originates from the religion, from Islam. Okay, so 2 conditions have been fulfilled. One, it has a separate name to it. Another one, it is originating from a belief which is based on a religion. 2 important things. Then it has an organization also. So all these 3 conditions are fulfilled. There are individuals who are forming the organization with a separate name and following religious beliefs which are based on in a religion. Okay, so Chishti and Sufi sect will be considered as a religious denomination. Same goes with Jehovah's Witness. And same goes with Rama Krishna mission. Now if you see Rama Krishna mission, it is not separate from Hinduism, but most of the religious beliefs come from Hinduism. So what is happening? The belief system originates from a religious background. One thing. Second thing, it needs to have an organization. So Ramakrishna mission does have an organization of itself, and it needs to have its separate name. So the propagator was Ramakrishna Paramhans. So the mission was established on his name by Swami Vivekananda. So it does have a separate organization. It have individuals who do follow the tenets and the beliefs of Shri Ramakrishna mission. They have a lifestyle according to Shri Ramakrishna mission and the belief system it holds, and that belief system depends on a religion. It is not separate from Hinduism. Okay, so these are called as religious denominations. So the rights which we are talking about to establish and manage institutions, to hold and own property, to administer it according to the laws, and to manage the religious affairs, they all are given to the religious denomination. So we have just now seen the three important conditions for an organization to be a religious denomination: the belief system based in religion, the organization, separate organization, and a separate name. So this is what is religious organization, religious denomination. Now let us come to clause number A, establishment and maintenance of religious and charitable institutions. So charitable can be anything. You can open up a hospital, let's say. Then you can also have a old age home. Then you can have educational institution. Anything can be there of charitable nature, of religious nature as well. So they have the ability and the right to establish and manage the charitable and religious institutions. Religious denomination have this right. So for example, Sri Ramakrishna Mission wants to start a old age home for the destitutes, old people. They have the right to do so. Okay. Jehovah's Witness wants to start an educational institution for itself. They have the right to do so. Ramakrishna Mission wants to start, or Chishti or Sufi sects wants to start a madrasa, let's say, for educational purposes, or a hospital. They have the right to do so. So that's what we are saying. Establishment and maintenance of religious and charitable institutions are allowed. Now the question arises, if a religious denomination have not established an institution, whether it will be given the management work or not, because these are two different terms. One is establishment, another is maintenance. So if you have not established a religious denomination, has not established an institution, does it have the right to manage it or not? Aligarh Muslim University, let's say, Aligarh Muslim University, it was established by a statute, by a secular government, by a statute passed by the parliament in the British era, let's say. What ends up happening here? Can the Muslims claim the right to manage Aligarh Muslim University, or will it be considered a secular institution and will be managed by the state? So when the religious denominations, these religious denominations have not established an institution of either religious nature or charitable nature, they do not have the right to manage it. Okay, they do not have the right to manage it. So Aligarh Muslim University, which has been established through a statute, will be maintained by the state, not by the religious denominations. Okay. Then comes the clause number B. This is important. Manage their own affairs in the matter of religion. What do you understand by this phrase, matter of religion? We have already seen in the previous article, article number 25, if we see clause number 2, it says that despite the people have the right to propagate, profess and practice their religion, but in the secular matters state can interfere and administer and manage the secular matters around it. Okay. So what do you understand by matters of religion? Religious denomination have the right to manage their own affairs relating to the matters of religion. So always there are two kind of categories, and these categories have been made by Supreme Court over the period of time in its judgments. And these two categories are, one, the matters of religion, and second, the secular matters. These secular matters. So if we take the example, the prayer, the tenets of the religion, the belief system of the religion, whether there is soul or not, whether there should be one god or many gods, Vasudev Kudumbakam or Atiti Devo Bhavo, or offering a glass of water to somebody who is thirsty is one of the major religious tenets which one can follow. Anything which makes the religion what it is, the core, the essence, the essentials and the particulars of a religion are considered as the matter of religion. Okay. But there are also several matters which are related to this, the concept of religion. Through these religion, people perform marriages also under the beliefs system. They do perform marriages, divorce unfortunately or fortunately. Then comes succession. Then also when there is one religious institution, let's say Ram Mandir or Jama Masjid or a big church or a big Gurudwara, it has its own finances. The management of finance is again a secular matter. So marriage, divorce, these are secular matters. Succession, these are secular matters. The maintenance of the property, the maintenance of law and order inside the temple, outside the temple, these are secular matters. It has no bearing on the essential parts of the religion. So a state can interfere in the secular matters, but not in the matters of religion. State through legislation or order cannot change any tenets or belief or faith system of a religion. That is not allowed at all. That is the religious freedom which is given to the people, to the organizations and to the individuals, both to the religious denominations and the individuals following it, that the state cannot interfere in the matter of religion. When we say matter of religion, it is about the core value of the religion, the essential part of the religion, which the state cannot interfere in. But when it comes to the secular matter, state can interfere. Okay. So the matters of religion and manage its own affair, state cannot interfere. And that is why the religious denomination have been given the right to manage their own affairs relating to the matters of religion. This is the second important clause of article number 26. But when it comes to management of secular matters such as law and order inside the temple, the maintenance of health and morality, all these things can be done by the religion. It can come up and it can interfere. Now, important article to be considered here is article 25, clause number 2, subclause B. Article 25, clause 2, subclause B. What does it says? It says then in social welfare, the interference of state is allowed. So if religion comes up with anything which is against the social welfare, the state have the right to curtail it. The state have the right to sort of declare it null and void. Even courts can interfere and state can come up with legislation when it comes to social welfare. Also, state can make provision for social welfare, and if somewhere few people are claiming that it is going against the religion, the core essentials of a religion, even then it is allowed. But if you see very closely, it is only the secular matters and always the secular matters which in a way goes against the social welfare schemes. India being a socialist state has to take care of the social welfare. Every religion, the core essentials of the religion can never go against the social welfare. If we see it very closely, none of that goes against the social welfare. But it's always the secular character. Remember, triple talaq. If we see the social welfare thing, it's going against it. So the Supreme Court, then the law has been brought to criminalize it. So social welfare is something where the state can interfere. Second thing is throwing open of Hindu temples. In the last lecture we have discussed that why to throw open all the Hindu temples of public character, that is to avoid any activity relating to untouchability, that untouchables are not allowed in a particular temple or a place. So to stop that, what the state can throw open the Hindu temples. That clause has been added under Article 25, clause number 2, subclause B. Now let us consider this article with clause number B. On one hand, the constitution makers are saying that the religious denominations can manage their own affairs relating to the matter of religion, and on the other hand it is saying that state can interfere in social welfare schemes. Okay, even if it is going against the secular nature of the religion. Think about it, if a temple comes up and says that few category of people are not allowed in the sanctum sanctorum, that from a long time, from the ancient time, this has been the practice that only few people belonging to a particular community will be the priests. It is against the untouchability clause. Article 27 also, if somebody is thrown out of the religion, excommunication it is called. What do you understand by excommunication? Again, censoring someone to be the part of a religion, that so and so is not the part of Islam from now on, and so person cannot be called as a Hindu from now on. That's called censoring somebody. It originates from Christianity, where a person was censored to be the part of Christianity. So if some person has been excommunicated, in some or the other way is been treated as an untouchable, which is not allowed under Article 17. But that's power of excommunication, that if somebody has lapsed on the religious tenets or the belief, and according to the core essentials, he cannot be called as a person of that belief. He cannot be called, let's say, a Muslim if he is going against the tenets and the beliefs of Islam, then such person can be excommunicated. Now this is a religious matter, a matter of religion, and the religious denomination have the power, have the right to manage their own affair. So think, if a person has been excommunicated, it is against social welfare because he have been termed as untouchable. He also loses his right to practice a religion of his choice. Okay, he wants to be called as a Muslim, he wants to follow Islam, but at the same time he has been excommunicated for not following it. In such a situation, which article, 25 clause 2 or B, or article 26 clause B, which article will be given priority? That is a debatable question. Every time these kind of question comes up in front of the Supreme Court, and Supreme Court sees it case by case basis. So case by case basis is necessary, because there cannot be one straightforward formula to take care of such matters. What if Article 26 clause number B is subjected to Article 25? That state have the right to come up with social welfare schemes, but at the same time the religious denomination have the right to manage their own affair. That simply means state cannot interfere within the religious matters. And this can be made opposite also. What if Article 26B is subjected to Article 25 clause 2? That all the religious denomination do have the right to manage their own affair relating to religion, but it has to be subjected to Article 25 clause 2 clause subclause B, that any social welfare scheme which is brought by the government has to be accepted by the religious denomination, even if somewhere it is going against the religious tenets or the beliefs. So this is a debatable topic every time such issues comes in front of Supreme Court. This concept is a bit deep for our UPSC preparation, but it is important as a civil servant to know these things, because on a day-to-day basis you may come up with such situations in future where you have to decide whether the state, because you will be the part of the state, and whether you have the right to interfere into this secular activity or not. Whether a person who has been excommunicated and comes to you for help, that I have been thrown out of my religion, and I am akin to an individual who is called an untouchable. So it is against the social welfare, and for that matter the state must give direction to the religion to take me back, but that is their religious affair. It is the matter of religion for that religious denomination. So whether this person will be allowed, this excommunication will be rejected or not, these are the things which are going to come in front of you in future. So you should be mindful about it. Now comes the clause number C. So clause number C and clause number D we have to look together, that these religious denomination do have the right to own property and acquire the property. Okay, and then these property have to be managed according to the law. See, all the property where a person can worship will not be coming under the core essential of a religion. Again, these two distinction, whether it is under the core essential of a religion or it is just a secular matter. See, properties can always, they are always a secular matter. The management of property, the buying and selling and acquiring of such property for religious purposes. Let's say a particular religious denomination comes up with a donation, large donation, and wants to buy a land to make a temple or to make a mosque or to establish a church. For that reason, they have the right to acquire that property. They have the right to manage that property also according to law. See, administer the property according to law. Okay, they want to establish a colony also around it. That's permitted. Everything is permitted. So the property, mostly all of them are under the secular activities by the religious denomination, not under the religious matters, but the secular activity. You are coming up, you want to acquire a property, you want to manage it, you want to administer it, you have the right to do it, and that will be considered as a secular activity which you have to follow and administer according to law. And the state can also interfere, because this is a secular activity. State can also come up and levy few taxes if it has to. They can also collect from you several taxes for the management of area around that property, or state can come up and levy taxes for the social welfare at as it does with all the other things. Some few other taxes can also be levied on you for social welfare. We will come up with article 27 and we will see how taxation for the promotion and maintenance is not allowed, but other kind of taxation on the religious denomination is allowed. So, state can also come up and interfere in the matters where the question of morality, health and public order comes up. That if you have bought a land, a religious denomination buys a land for establishment of a religious institution, but nearby is another religious institution and there can be a problem of law and order. So, in such affairs the state can interfere. So, the property is always a secular matter, but then what about Ram Mandir? What about Babri Masjid? What about Shishganj Gurudwara? What about the mutts all around, all over India? What about the important religious places, Vaishno Devi? Okay, what about them? So, when a property becomes the part of the religious matters, two kind of matters we have studied. One is the religious matter, and other is the secular matter. Properties always 99% of the time comes under secular matter, but there are few, and these can be administered, have to be administered according to the law. These can be interfered by the state also, but there are few properties which comes under religious matters, and those are those important essential properties of religion which have been site of those religion from a long time and forms the part of the essential value of that religion. Essential value of that religion, and that is that particular place is so important for the religion that the state cannot interfere in it. So, these are two kind of property. Even in such important site, the maintenance of public order, health and morality will be seen by state. Okay, it will be seen by state. For example, Ram Mandir temple was inaugurated. What happened? The security around it was seen by state. The law and order maintenance inside the temple was also being looked up after by state. But that site is so important to a religion that it is considered as a religious matter, not as a secular matter. I hope you have understood this distinction. Always keep in mind when you are studying these articles from 25 to 28 relating to freedom of religion, the state interference, then you will understand what is secularism in India. The secularism in India is a bit different from the secularism in the West. The state here cannot promote and maintain any religion, cannot levy a tax for maintenance and promotion of any religion, but it gives same protection to all the religion. It cannot interfere in the core religious essentials of a religion, but the state can interfere in the secular matters. Also, the state, if it makes any provision relating to social welfare, that is also allowed. So, state is not a separate entity from religion. They do go hand in hand, but there is a limit to which state can interfere in the religion. Whereas in the West, if you see, state is a separate entity. State and religion both are separate entities. Both, the state cannot interfere even in the establishment or in any other matters. It has nothing to do with what religion comes up with, even their secular matters and other things. But in India, state does have the right to interfere at several places where it is about social welfare, whether it is about upholding the public order, morality and health of the people, where it is about the social welfare and secular matters. Now, I think we have sufficiently studied this article. Let's move to article number 27. It's a simple article which says that any taxation whose proceeds will be used for promotion and maintenance of a particular religion is not allowed, and nobody must be compelled to pay such taxes. Okay, for promotion and maintenance. Promotion and maintenance of a religion through levy of a tax is not allowed, and nobody can be forced. But several taxes are allowed. For example, pilgrims. If you want to give better facility to the pilgrims, several taxes can be levied. Okay. About education. If you want to provide better education, for that better infrastructure is needed, good quality of teachers are needed. In such a situation, what ends up happening, that the state can levy a tax for this. This again secular matters. Okay. So, just by providing good facilities to pilgrims through taxation, the state is not promoting or maintaining any religion. Okay. So, there was a case where because of the riots, few colonies of Hindus and Muslims were destroyed, and then the government came up with the idea that state will spend some fund for the maintenance and for the reconstruction of those colonies. So, there was a case in the Supreme Court saying that the funds are the levies and the taxes which have been paid by the people, and such taxes cannot be used for the promotion and maintenance of any religion. Supreme Court in its judgment said that reconstruction of the destroyed colonies of Hindus and Muslim after the riots cannot be considered as promotion of any religion. That's a social welfare thing and must be done. So, on case by case basis, court comes up with these judgments. There is no one straitjacket formula which has to be applied. So, that taxes for better facilities to pilgrims, that's allowed. That cannot be called as promotion of a religion. Then again, for education, that is allowed. For construction of colonies which have been destroyed in riots, that's again not a promotion. That's also allowed. So, no taxation is allowed for the promotion and maintenance. Those tax which have been levied on the people for the promotion and maintenance of any religion is invalid. Any law bringing such a taxation on the head of the people will be invalid. But if it is fulfilling some other agenda of the government, agenda of the society, then it is allowed. Now let us come to article number 28, which talks about educational institution. Article number 28. It has 3 clauses. One is that in the wholly owned by the state, if the state completely owns a educational institution, no religious instruction is permitted. Religious instruction. This is an important word, religious instruction. So, wherever the state is holding the educational institution completely, it is owned by it, recognized by it, funded by it, there The religious instruction will not be given, it is not permitted. What is this religious instruction? Religious instruction is something which relates to the tenets, the beliefs, the worship of any religion. Those are religious instruction which tries to promote a religion through persuasion. So, if a teacher in your school teaches that a particular religion have this and this way to pray which is better than any other religion, or these are the religious tenets and beliefs which makes you a better human being, and that instruction which is given by the teacher ends up in persuading you, ends up in influencing you, it ends up in making you a follower of that religion, so to say, that is called religious instruction. Okay, what needs to be followed, how it needs to be followed, what needs to be done, which is talking about the core value, the essential of that religion is called as the instruction. So, such instruction are not permitted in religious institutions owned by the state, completely owned by the state. Second, what if you are studying in an educational institute which has been established by a religious denomination? For example, a madrasa. For example, a Sanskrit college which has been established by Ramakrishna Mission. Or let us say a school which has been established by a temple trust, any religious endowments. In such a situation, these religious instructions are allowed, because mostly what ends up happening is the followers of that particular religion send their children to such institutions, and for them the religious instruction are important, and that is the reason this clause 1 does not apply to the religious denomination. The educational institutions which have been established by religious denomination. If any educational institution has been developed or established or maintained by religious denomination, then the religious instructions are allowed. And comes the third clause. If state is administering, any religious institution, any educational institution, if state is administering any educational institution and if state is funding it, but it has been established by the trust or by the endowment which is a religious denomination, in those cases also religious instructions are permitted, but only after the consent from the person who is hearing those religious instruction. And in the matter of minors, the consent has to be taken from the parents. Okay. So, any educational institute which have been managed by the state, managed or administered by the state, but has been established by the religious endowment, or has been established by the trust, religious trust, in such a situation religious instructions can be given, but only after the consent. In the matter of minors, the consent has to be taken from parents. In the matter of majors, the consent have to be taken directly from them, but only after consent such religious instructions will be given. And if a person refuses to take these religious instruction, the person must not be forced to listen. So, this is what Article 28 talks about. It talks about three categories where one of educational institution, where the state completely owns that educational institution, and for that matter no religious instruction is provided. Second, that a religious denomination establishes a religious educational institution, and in such educational institution instructions are permitted. The third category, a place which has been managed or administered by state but has been established either by the trust or by the religious endowment. In such cases the consent needs to be taken. So, these are the three categories, important categories about a religious instruction needs to be given in educational institutions. So, this is how we have completed article 28. We have also seen article 26, which talks about these four important matters where a religious denomination has its right to manage its own affair in the matter of religions, have the right to own the property, acquire the property, and have the right to establish and maintain any religious or charitable institution. Then article 27, we have seen that taxation, where the taxation is allowed and where the taxation by the state is not allowed. There is no taxation allowed in the matter of promotion and maintenance of any particular religion, but if the state is levying any tax for the betterment of the society, for the betterment of the social welfare, that is allowed. And then we have seen article number 28 as well, which talks about educational institution. We have already seen article 25 in the previous lecture. So, this completes our right to freedom of religion in India. This is the completion of our topic. Now, we will talk about cultural rights in the next topic, in the next class, which pertains to article 29 and article number 30. Thank you very much for listening, and if you have any question you can post it online. Thank you very much.